How's it going, everybody? Welcome back to 2A News Now. And I appreciate everybody that takes time tuning in to my videos. Real quick, I want to thank all the new subscribers to the channel. This month, so far, there's 450 new subscribers. I thank each and every one of you for subscribing to the channel. I'm going to tell you a story about the saga of a man named Bryan Range. Nearly 30 years ago, when living in Pennsylvania, for whatever reason, he committed food stamp fraud, which was not a felony, and he didn't do any time. And since federal law generally says it's illegal for anyone convicted of a crime, punishable by imprisonment for over 1 year, Bryan Range was no longer able to possess a firearm, even though he wasn't convicted of a felony. And it was a non-violent crime. And evidently, Bryan Range didn't know anything about this, because in 1998, he tried to buy a firearm, but he was rejected by the state's instant background check system. And Bryan Range's wife thought the whole thing was a mistake, and she gave him a rifle. Quite a few years later, he tried to buy a firearm again. And once again, he was turned down. So he took a look into the matter himself, and what did he find? He was prohibited from carrying a firearm because of his 1995 conviction. And let me remind you, what he was convicted of was not a felony and was not a violent crime, and he didn't do any time. But once he found out he wasn't allowed to possess a firearm, the firearm that his wife had given him years ago, he sold to a dealer. So after nearly 30 years of not having his Second Amendment right to keep and bear arms, Bryan Range got an early Christmas gift. On December 23rd of this year, the Third Circuit Court of Appeals, who had already ruled on this earlier, that a person that commits a non-violent, non-dangerous misdemeanor and hasn't been incarcerated cannot be deprived of his or her Second Amendment rights. But to give you a little bit more background, I mentioned that the court had ruled earlier on this. In June of 2023, the same Circuit Court of Appeals restored Bryan Range's Second Amendment rights. But because the circuit was split, the case was sent all the way up to the U.S. Supreme Court. But they bounced it back to the Third Circuit Court of Appeals, where they made their decision on December 23rd. The Third Circuit Court of Appeals ruling stated, Bryan Range remains one of the people protected by the Second Amendment, and his eligibility to lawfully purchase a rifle and a shotgun is protected by his right to keep and bear arms. The court also wrote in their statement, in sum, we reject the government's contention that felons are not among the people protected by the Second Amendment. Heller and its progeny lead us to conclude Bryan Range remains among the people despite his 1995 false statement conviction. And then the court ran this through the Bruen decision to see if there is any similar laws in place during the founding. And they also wrote, because the government has not shown that a republic has long-standing history and tradition of depriving people like Range of their firearms, cannot constitutionally strip him of his Second Amendment rights. It's just unbelievable that Bryan Range had to wait almost 30 years to get his Second Amendment rights reinstated, which is absolutely ridiculous. And now I hope he can buy his rifle and his shotgun and whatever else firearms he wants to purchase. And I really would like to hear from you guys in the comment section. Should Bryan Range have been stripped of his Second Amendment rights to begin with? As always, I appreciate everybody that supports the channel. After every video that I post, you guys are always crushing it by liking, sharing, and subscribing, and hitting those post notifications, as well as leaving a lot of comments. And I'm very grateful that you do so. And I invite all of you to come back and watch my next video.